The worst misconception that many entrepreneurs share. And tell me if this is your mindset. I can just pay a lawyer to set up a business legal structure and draft an operating agreement, and then the legal part of my business worries is settled. I can put that behind me and solely focus on the front end. Who thinks that right now? I certainly used to. Stick around. Today, we're going to discuss why that mentality will cost you. We'll explore 3 essential legal trade concepts that will keep you and your business protected, and we'll go over things you need to know before you draft your operating agreement. Welcome to The Financial Verdict, a channel dedicated to providing you with valuable information to help you thrive. I'm Rihua Xu, and I am very glad you can join me today. Quick disclaimer, while I am an attorney in the United States, I am not your attorney. I hope this general information may prove useful to you in aiding your research, but this is not legal advice. Before we delve into the topic of operating agreements, specifically, I want to discuss 3 essential concepts that are prerequisites to understanding how to systematically protect a business. Because you can learn static information anywhere. I can recite you law. I can show you well-drafted contracts, but that's really not much use to you unless you're able to see the full picture. What we're endeavoring to do here is to see that full picture by exploring winning concepts and providing experienced analysis. How a professional view the problem is far more important than any one given solution. If you just have a solution, you're not able to apply it to a different situation. If you truly understand how the best goes about solving the problem, then you're dangerous. Imagine you're learning to play chess for the first time. Someone gives you a pamphlet that just shows you the rules of the game, like how the pieces move, and tells you that your opponent is to be Magnus Carlsen, the best chess player in the world. You only know the rules. You have no chance whatsoever competing against anyone who utilizes strategies and deploys tactics, let alone the best to ever do it. You think that's a ridiculous analogy because when would you ever play against the best? There are individuals and entities whose sole income is derived through predatory legal practices, exploiting the legal system through targeting businesses right up to the very edge of the bounds of the law. They want to destroy you in order to enrich themselves. Unlike a competition world champion, predators are not looking for skilled opponents. They would love nothing more than to target an unprepared business and take you for everything you're worth. If you own a business, anyone can impose a proverbial game of chess on you at any time. Play well, and you may get to exact revenge against them for filing a frivolous suit. Play arbitrarily, and you may not get a chance to play ever again. If you're going to play, you play to win. Knowing the law is just knowing the rules of the game. It's important, but it's just the beginning. The most well-drafted operating agreement in the world is of limited use to you as a business owner unless you conduct your day-to-day in accordance with it. Your operating agreement is like your written strategy to safeguard your business. The concrete plans you design in adherence to and in furtherance of your operating agreement are your tactics. The implementation of those tactics to your day-to-day business are your operations. What I just described is commonly referred to as organizational planning and execution on 3 levels: strategic, tactical, and operational. Let's break this down. In my experience, successful entrepreneurs have incredibly well thought out business strategies on how to design products, how to market, and how to deliver, and their tactics and operations towards monetization are no less meticulously planned. But they leave their business legal structure, the castle that safeguards everything they have earned, undefended or underdefended. In fact, many incredibly gifted and hardworking entrepreneurs give no thought whatsoever to their business legal structure until a catastrophic event occurs. When the enemy is already at the castle walls, it is too late to fortify. The critical difference maker between the long-term success or failure of any business enterprise is whether the legals of the business are treated with as much diligence and due care as the business itself. Surviving lawsuits is a pragmatic necessity of business, or you're just earning money for someone else. And your preparation for this necessity begins now, not when you get served with legal papers. This is a major concept, and it is foundational to everything we're going to discuss. Your business legal structure is your castle, and requires organizational planning and execution at the strategic, tactical, and operational level. Let's give an example to illustrate that. Let's say you own a small skydiving business and you've hired 2 experienced skydivers as instructors. Your business model is simple. You mostly market to new skydivers. You pilot customers up to 12,000 feet in the Cessna 182 you own, where your customers jump from the plane in tandem with their instructor. They free fall through the air for about 30 to 45 seconds before the instructor deploys the canopy and both participants glide safely back to the ground. Or so you hope. If that's as large as your operation gets and you're really good, really hands-on with all of your customers and really lucky, maybe you won't see the inside of a courtroom for the duration of your business. But if you want to grow that business, unfortunately, the probability measure function in statistics tells us that if something is a possible event, if you throw enough darts at the sample space, which is the set of all possible outcomes, eventually every possible outcome will occur. So even though skydiving is relatively safe recreationally, statistically speaking, if you do it enough times, something bad will eventually happen. Say you're really good at this business and customers are flocking to you faster than you can keep up. Soon, you have 10 Cessnas and 20 employees, and you're doing 30 times more jump per day than when you first started. You can't possibly oversee every jump yourself. You're no longer the sole person doing hiring. And you see where I'm going with this? The relationship between business growth and litigation risk is not proportional or uniform. A 30x flip on an operation like the one I've described. It is not a question of if, but when you'll get sued. Say you were arbitrary about your business legal structure and one day something terrible happens. Let's say a plane crash. The mechanic you hired failed to properly maintain one of the planes. Your pilot is forced to crash land shortly after takeoff, and sadly, your customers and your employees on board are severely injured and claim disability. As a human being, you're heartbroken, but ultimately you think to yourself, this isn't the fault of my business practice. I hired this particular mechanic at a premium because he is supposedly the best in the area. Nevertheless, you find yourself a co-defendant at trial with the negligent mechanic, and the jury returns a verdict that says, we agree that this is mostly not your fault. We find you only 10% at fault for negligent hiring because the mechanic has caused a similar accident in another state 8 years ago. Okay, so what the jury is basically saying is that they decided you failed to execute reasonable care in hiring your contractor. You are in a joint and several liability state, which means that you're on the hook for the total judgment if the other defendant is not able to pay his share. The judgment is $9 million. The mechanic has no insurance and is insolvent, and after all your legal fees, you don't have anywhere close to that. Now, your business, your planes, your money, everything is gone. While that accident truly might not be your fault, not having a business structure designed to protect against an incident like this is your fault. Because we live in the real world, and just because you did everything reasonably possible to prevent harm does not mean that harm won't happen, and it certainly does not mean that you won't be forced to pay for it when it does. But if you had a calculated and deliberate approach to organizational planning and execution on 3 levels, strategic, tactical, and operational, and say you watched my holding company video and implemented a business structure to protect your assets, your situation will probably be materially better. So, how does this concept play out practically? Well, first, on a strategic level, on day one, not when something happens, okay? On day one, we recognize the threat of commingling of assets and funds and the threat of the corporate veil being pierced. The corporate veil is a legal concept that shields the personal assets of owners from the liabilities and debts of the LLC or the liabilities and debts of one LLC from another. When this veil is pierced, meaning when a court decides that this business to personal separation or business to business separation should be disregarded, you can become personally liable for the LLC's obligations, or one LLC can become liable for the obligations of another, which in either case completely defeats the entire purpose of setting up a limited liability entity in the first place. I'm not going to get too deep into these concepts as I go over all of these in details in my other video. But the general idea is keep everything separate. Never commingle anything between businesses. Follow all business formalities. Keep each LLC reasonably funded. So, threat analysis one, you have all your eggs in one basket. You own 10 planes along with $500,000 liquid. You recognize the threat that if you keep all 10 planes and $500,000 in the same legal structure, you may lose all of them in one single catastrophic event. You may not know what that event is, but you can think of several possibilities with common sense of why leaving all of your assets under one business entity is a really bad idea. Further, your business may get sued for a different reason that has nothing to do with your planes or skydiving. It could just be a slip and fall on a wet floor on your way to your office. But your planes and cash are still legally targetable assets if you do nothing to separate them from your main business. So, you need a strategy. Strategy number one, segregate assets as much as possible. The tactics you use to further that strategy may be to create a holding company and subsidiary structure where every single plane is owned by a different plane subsidiary LLC and is separate from the main skydiving business. The main skydiving business, Skydiving LLC, could operate at arm's length with plane subsidiary LLCs and enter into separate lease agreements that delegates all of the legal responsibilities of the mechanical safety of the plane to plane subsidiary LLC. So tactic number one, create holding company and subsidiary structure with sufficient formalities and separations as to keep corporate veil intact. That requires you to take the operational steps of opening separate bank accounts, funding them adequately, executing separate lease agreements, making sure you're following through with all terms of your contracts between your businesses, such as paying insurance premiums, leases, and wages from the correct business account every single time, and making sure you don't commingle funds on the day-to-day affairs, like, for example, when you're paying for refuel or repairs on your planes. The list goes on. But the idea is you are now treating your business operation as separate businesses under one holding structure that do business with each other at arm's length. A second tactic you may use to further the strategy of asset protection through segregation of assets is to create intellectual property LLC that owns the trademark rights of the main skydiving business's branding. And again, I cover this in detail in my holding company video, so I won't get into too much detail here, but the main idea is you create a subsidiary LLC in a pro-business, low-tax state like Wyoming, and you let that LLC own the intellectual property rights to the trademark, the branding of your business. Every time you make a sale with your skydiving business, you pay a portion of the profits to Intellectual Property LLC via contractual trademark royalties, reducing your net revenue in Skydiving LLC, which reduces that LLC's total exposed assets. Going back quickly to our first tactic, notice how as a collateral benefit, by executing lease agreements for the planes in all those different LLCs, you are also dispersing capital in different businesses, making your total liquidity hard to target. At the operational level, let's analyze this, okay? How well did you execute each step? The legal structure, was it correctly implemented at inception? Did you do your own research? Did you hire a good lawyer? In terms of your day-to-day, are you keeping to all your business formalities? Are you making sure to never commingle personal assets with business assets and assets from one LLC with the assets of another? And are you keeping meticulous records for each and every one of your businesses and its transactions? Are each of your LLCs adequately funded if we view them independent to the other? Are you actually performing the contractual obligations from one business to another each and every time? Does those contractual obligations pass the lab test? Okay, that's not a legal test, that's my test, okay? Can you say with a straight face in court that the contracts are good for both businesses? Are each making a little profit, even if it's just nominal, through its business dealings within your business structure? This is by no means a comprehensive checklist. So let's assume you did all this, and let's go back to our prior example. The accident happens and Plane Subsidiary LLC and Skydiving LLC gets sued. Let's assume your setup was done correctly and you operate your day-to-day properly and the corporate veil is intact. The plaintiffs now cannot pierce the veil and attack your other unrelated entities because they can't prove there is a factual nexus between those businesses and the incident leading to your injury. What you should immediately notice is that, unlike the prior circumstance, 9 out of your 10 planes are not exposed to judgment. Okay? Compare and contrast with that with all of your planes being exposed before. Skydiving LLC also has less liquid assets overall because you design a business structure to legally funnel money out after every sale to Intellectual Property LLC and every month to the 10 plain LLCs long before a problem had arisen. If you had tried to do this after something bad has already happened, meaning in contemplation of litigation, the courts will say, no, you're disingenuously trying to hide assets from judgment, and it won't allow that. Which is why I always say, it's too late to fortify when the enemy is at the castle wall. Going back to our example, after judgment, even if Skydiving LLC and one of the plain subsidiary LLCs goes down, the bulk of your assets remain safe. You can rebrand and start again. If you have the mindset to approach organizational planning and execution in this calculated and meticulous manner, this incident, however tragic, is in the business sense a bump in the road. If you were arbitrary and just threw everything into one LLC or, God forbid, no LLC at all, this may be the end of the road for you. Now, I've heard people say, why not just use insurance? Absolutely. You always want to carry sufficient business insurance, not just to protect yourself, but also as an ethical person. If something bad were to happen in your business involving your customers or employees, I'd assume you want people hurt on your watch to be taken care of. But say you carry a 10 million liability policy. What if the judgment, instead of 9 million, was 90 million? Relying on business insurance is a tactic, but it cannot be your only tactic to address the strategy of asset loss mitigation. Now, this was just one example of a strategy and tactic that protect against a certain type of threat. If you own a skydiving business, your legal business structure better implement many more strategies to cover a multitude of foreseeable threats that is designed from your operating agreement. Just off the cuff, how do I minimize taxes? How do I reduce the risk of IRS audit? What about tort risk that's inherent to skydiving, such as parachute failure or just hard landings? What about tort risk from vicarious liability? What if my employee harms another employee or a customer? Your job as a business owner is to create and consistently update the business legal structure to address those foreseeable threats. You need to systematically think about risk mitigation and actively implement those risk mitigation solutions into your business legal structure. So I want you to think of it this way. How do I minimize the chances that a serious negative incident would occur at my business? If a negative incident does occur, how do I minimize the chances that I get sued? If I do get sued, what legal structure do I have in place to leverage favorable settlements and lessen my exposure at verdict? If I am seriously compromised at verdict, what legal business structure protect my assets from judgment? Until you hire an in-house counsel, that's your job, and how you protect your money is just as important as how you make your money. So with that concept explored, let's put down that last example and think of something more mundane. Some kind of irreconcilable business dispute has occurred and litigation is now imminent. You either need to sue or are getting sued. If you're a successful business owner, the probability of being involved in mundane litigation in your lifetime is a virtual certainty. There are millions of lawsuits filed in state courts each year in the United States. As you would expect, the likelihood of your business being involved in litigation disproportionately increases as you pull in more revenue. If you were paying for a business consultation with me, I'd first explain that a business structure, an operating agreement, or any contract is not just a formality. It's not something you have to do to get it out of the way, but when it's done, you never have to think about it again. If that's the way you think, chances are you will find yourself at some point on the losing end of a legal battle to someone more prepared, more calculated, and more meticulous than you. When you're reviewing what terms should be implemented in any contract, and again, an operating agreement is just a form of contract, how each term can affect the outcome of a potential litigation is where your primary focus should be. Because whether it be operating agreements, the LLCs it pertains to, the only value of a business construct is the litigation deterrence or litigation advantage it provides. This is our second essential concept, and I'm going to say it again because it's important. The only value of a business construct is the litigation deterrence or litigation advantage it provides. And to borrow from Dr. Stephen Covey, you begin with the end in mind. What risk, what threat are you trying to protect yourself from? The more you adopt the mentality that when you draft any legal document, design any business structure, that you have the end in mind, okay? The worst case scenario in mind that the document or structure is intended to protect you from, the less likely you would actually find yourself in court, the less likely you would actually find yourself in that bad situation that you first contemplated. The more fortified and buttressed your castle is, the less likely an enemy is to try and lay siege. The best way I found to illustrate this example is when the opposite is true, when a contract provides no deterrence and no advantage. Let's say you own a local restaurant selling burgers, and your friend Wayne is the regional farmer. You two are old friends and grew up together. You and Wayne have also been doing business with one another since your restaurant's inception, and he delivers lettuce and tomato from his farm to your restaurant every single week for over 10 years. Are you going to exercise over-the-top legal formality for every transaction with terms that punish the other party in event of breach? Of course not. That would be pointless. You'll probably execute an invoicing slip or maybe an FOB contract or a long-term agreement with a basic statement of terms for revenue recognition and potential insurance claims. Now, why wouldn't you want to go over the top? Because excessive legal formalities guarding against breach are not only unnecessary in a situation like this, but it may hurt your business and personal relationship. Let's say, for example, Wayne's truck breaks down one week and he fails to deliver his produce on time. Are you going to sue him? Of course not. That would be completely irrational. So when we're drafting contracts with Wayne regarding the purchase of his produce, we can say it has zero litigation deterrence against the other party because it is improbable in the event of breach that either side would take legal action against the other. Since we're in separate businesses, if Wayne one day becomes an unreliable merchant, you'll simply find another supplier. After all, you're not in business together because you're obligated by a contract. You're in business together because of mutual trust and mutual financial gain. Even if Wayne weren't your friend, it's probably not the best long-term business decision to sue local farmers for damages for being late on a food shipment. So the only value of the contract here is for revenue recognition, tax compliance, and potential insurance claims. So in other words, the value of the contract is deterrence against the IRS from enforcement action because you are remaining compliant by keeping records of expenses, and defense advantage in potential litigation from the IRS against you because you kept records as evidence of legitimate business overhead. Same thing with the insurance company. Say you took out delivery insurance and the delivery truck gets into an accident on the way and the produce is destroyed. The existence of a properly executed FOB contract is deterrence against the insurance company from failing to pay the claim because they recognize it is an advantage in litigation against them should they fail to honor their contractual obligation. The contract itself has no value outside of how you position yourself to enforce it. Against Wayne, the existence of the contract is essentially meaningless because the terms will not be enforced upon breach. So, recognizing this, if we're thinking at the beginning with end in mind, what is the ostensible purpose of the legal terms that's being drafted? What's the exposure for me in the worst case scenario that I am attempting to protect myself from? And how does this legal framework protect me from harm and or mitigate my losses, okay? How exactly does this contract and every term in any contract serve my interest? In this example, for example, we can quickly see that the contract has very little to do with the actual surface level purpose of ensuring Wayne's timely sale and delivery of goods. In fact, if the threat from and necessity to guard against the IRS and the insurance company were not present, you wouldn't have a contract with Wayne at all. There would be no point because the only value of a business construct is the litigation deterrence or litigation advantage it provides. We are not in the business of taking action where there is no value. Let's take a look at this concept from another perspective. Company A agrees to sell 1,000 Model 2 TVs to Company B for $100 each. Unlike the prior example, these businesses have no prior dealings. Legal teams for both companies put this agreement into writing just like that and signed it. It's technically a valid, enforceable contract on its face. There is an offer, 1,000 Model 2 TVs, consideration for the offer, $100 for each TV, and acceptance, both parties signed. Prior to signing and during negotiations, Company B orally stated to Company A that the primary reason it chose to do business with Company A is because the latter has a reputation for effectuating delivery of goods within 30 days, and that Company B rep said it needed that 1,000 TVs within 30 days because it needs that TV smart technology for a tech conference it is running in 35 days. Company A rep response, we totally understand. We'll do our best and currently see no reason why that wouldn't happen. What is the primary value of the contract here? If you hire a lawyer and he says the primary value of this contract is that it increases the probability of specific performance on the terms of the contract, really consider someone else, okay? It does not. That lawyer either does not understand the realities of business or is choosing to not fully inform you, and having a lawyer that's drafting your legal documents with no nuanced understanding of legal consequences or can't be bothered to explain them to you is not much better than having no lawyer at all. Having a contract with no teeth does not make it more likely that specific performance is rendered. Companies operate pragmatically. If it benefits Company A to go through with the sale, and I'm assuming in most circumstances it would, or why agreed to sell in the first place, the company doesn't need a contract to incentivize them to fill the order. Companies fill orders because it's in their best interest to do so. If something materially changes and the company believes it will be more efficient to breach the contract, it will breach the contract. Legally, we call that efficient breach. A breach of contract in which the breaching party finds it cheaper to pay damages than to perform under the contract. All right, it's an intentional decision to not uphold one's end of an agreement. And I'm not saying it's a good thing or that this practice should be supported. I'm just stating a fact that this happens very often. So let's say 30 days have passed since the signing of the contract, and the market value of Model 2 TVs have since skyrocketed to $500 per unit due to scarcity, okay? Other businesses suddenly realize that the unique capabilities of the smart technology, and now there is a bidding war for these TVs, okay? Company B sends a demand letter to Company A to satisfy the contract, and Company A responds in writing refusing to ship goods, but instead replying that it believes the reasonable industry timeframe to effectuate delivery is 60 days. Now, what's Company B's remedy? Company B could sue for breach, but there is a good chance Company B will not prevail. The original contract never specified deliver by date. And under most jurisdictions where the Uniform Commercial Code, okay, the UCC, and the statute of fraud applies and is conventionally interpreted, there's a good chance that Company A may be able to successfully argue that since there was never a written agreement as to the date of delivery, that delivery outside of 30 days is still within reasonable industry standard, and that the court ought not to consider the colloquy as it is inadmissible. As the contract is silent on the date of delivery, the Uniform Commercial Code only requires delivery within what is quote-unquote reasonable time. Company A then fulfills delivery on the 60th day when the price of Model 2 TVs has depreciated in value and outside of Company B's window of need. Company B is now stuck with 1,000 units of TV that it no longer needs. So Company B's legal team did a horrible job because the contract they agreed to brought Company B no value. Because remember, the only value of the contract is the litigation, deterrence, or advantage it provides. And this particular contract provided little to no deterrence value against Company A's decision of whether to breach and conferred little to no advantage at litigation. Now, what if Company A had timely delivered 1,000 units of TVs, but Company B fails to pay after delivery? Even though the contract is silent on when payment would be rendered, the default rules of the Uniform Commercial Code would apply, and Company B's failure to render payment at or immediately after delivery and inspection of goods would constitute a material breach that a court would certainly enforce. I'm not using this example to talk about the application of the UCC, okay? That's not the point at all. I just want to illustrate the point that a contract's value isn't absolute. It's relative. And if you're not prepared, if you don't understand the rules and make every effort to protect yourself in those situations, and if you're not strategic, you will get played and lose money. The balance of power between the parties in any contract is zero sum. This isn't to say that both parties can't mutually gain in the execution of a contract. Don't get me wrong. Mutual gain through the execution of a contract is the norm, or you wouldn't ever sign them. But in conflict between one party of a contract to another, the value of the contract is relative. It is zero sum because where there is a favorable enforcement term that benefits one party, it is directly to the detriment of the other. That same contract that nets Company A high litigation deterrence and high litigation advantage over Company B does worse than nothing for Company B. It only provided a false sense of security for Company B. Company A's legal team did a fantastic job because the relative advantage it gained against potential enforcement action from Company B is high. It created a series of enforceable leverages against Company B and mitigated reciprocal leverage from Company B. Likewise, depending on your needs, your goal isn't to create the most sophisticated operating agreement or whatever contract you have in mind. Your goal is to create a legal structure that maximizes your relative advantage against foreseeable threats. This is the third major concept of today's video. Your goal in creating any legal instrument is to maximize your relative advantage against foreseeable threats. Your goal isn't to mark off a list of checkboxes that customs and practice dictates must be included. You only take action that maximizes your relative advantage against foreseeable threats. Imagine if Company A's legal team during the drafting process reminds Company B's legal team, hey, you forgot to include a clause for date of delivery. Not only would that have been foolish, I would say that that act would violate the attorney's fiduciary duty to act in the best interest of his client, because letting the contract lie silent on date of delivery is to Company A's material advantage. All right, with these concepts in mind, we can now have a meaningful conversation about operating agreements. The purpose of a well-drafted operating agreement is that it deters litigation from happening in the first place. But when it does, it provides the drafter with a relative advantage against foreseeable threats. Depending on the owner's finesse in both implementing the right terms in the operating agreement itself and in his day-to-day rigorous adherence to that operating structure, the advantage created through this process may be insurmountable for your adversaries. When a client comes and consults with me about an LLC-related litigation, the first question I always ask is to see the operating agreement. If the answer is an operating agreement was never drafted, I immediately think two things. One, I need to protect my time and charge a higher retainer because I base my retainer on my hourly rate multiplied by the number of hours I estimate the case will take. Litigations about a business with no operating agreement is typically going to be messy, will probably require evidentiary hearings involving he said, she said, and thus will require more motions to be filed in court. There will probably be less leverage to settle the case for favorable terms at an earlier stage of the litigation. All of this tells me that the case will likely take more time, and unfortunately, my time is very expensive. And I mean unfortunately sincerely. While I need to protect my time and make the best living I can for myself and my family, just like you should, I hate to see small business owners get decimated by legal fees, even when they did nothing wrong and, quote, win the case. When you prevail in court but lose your nest egg in the process, that's not winning at all. That's tragic. 2, even before hearing the facts of the case, I know there is less certainty of prevailing at verdict because whether I can generate leverage is now arbitrary, and therefore I am less useful to you as a legal operator. A good litigator strategy typically involves generating as much pressure as possible against the adversary while protecting your own case against incoming pressure. Pressure creates openings, highlights vulnerabilities, and greatly increases the chance your adversary makes a mistake, and this in turn generates leverage to settle favorably. There is a limit to what even the best litigators can do without leverage. If there is no legal foundation to mount a fight and generate leverage, there is a limit to the kind of strategy and tactics that can be used, as the case is now more arbitrary than it can be controlled. And therefore, the outcome will be more chance-based than skill-driven. It's like rather than playing a game of chess, we're settling for flipping a coin. So, good litigators who pride themselves on winning consistently and who enjoy the intellectual stimulation of deploying effective strategies are not really going to want to take that case. Yes, there's hubris here, but good lawyers have their choice in which cases to accept because they have more people who want to hire them than they have time. Therefore, successful trial lawyers are selective and not going to want to take a case where they cannot showcase their skill. So, the lawyer that does accept arbitrary cases, draw what conclusion you may. You can see how even before we get to what went wrong to warrant a lawsuit in the first place, not having an operating agreement already nets a practical disadvantage in selection and cost of available legal talent when something does go seriously wrong. Let's move on and talk about why an operating agreement is so important. I hear this a lot. Isn't one of the primary benefits of using an LLC the lack of required business legal formalities? That's true in the literal sense, but being lax here is a huge mistake. While most states do not require LLCs to have an operating agreement, the belief that having an operating agreement and business formalities are not important is a death trap. First, ignoring the importance of well thought out, clearly drafted operating agreement greatly increases the chances that you'll lose in litigation brought against you by your own business partners and investors. Think your business partners won't ever sue you? Think again. Money does strange things to some people. The co-founder of Facebook, Eduardo Saverin, once great friends and business partners with Mark Zuckerberg, eventually received a significant undisclosed amount after settling a lawsuit alleging that Zuckerberg intentionally diluted his ownership stake. Uber's co-founder, Travis Kalanick, was sued by his own investor, Benchmark Capital, who alleged fraud and breach of fiduciary duty. Co-founder of Tesla, Martin Eberhard, sued Elon Musk, alleging that Musk had conspired to discredit him and unfairly pushed him out of the company. These are just three well-known examples. It happens all the time. As a prudent entrepreneur, you need to reasonably prepare for all foreseeable risks or fall victim to them. Second, not having a clearly drafted operating agreement also makes it easier for your adversaries to pierce your corporate veil because it undermines the separation between your personal assets and those of the LLC. Why does the failure to have an effective operating agreement in place make it easier for your corporate veil to be pierced? That's because an LLC without an operating agreement is starting off lacking business formality, which makes it easier for others to claim that the LLC is not a separate business entity, but merely an extension of the owner's personal affairs. Without an operating agreement, a business does not have defined roles and responsibilities, has unclear capital contributions between members, has lack of demonstrable proof that there is an adequate governance, has lack of proof of member consensus on decisions, and this usually leads to undocumented or underdocumented financial transactions and commingling of business and personal funds. Why is all of this really bad? Because someone will come along and sue you and try to take everything you have ever worked for. It happens all the time. At a minimum, what happens when you don't have an operating agreement is that critical aspects of its operations are governed by default rules set forth in state law, regardless of what you think you may have agreed to with other members. That's a nightmare. Even if you are a solopreneur, the most important aspect of why you set up an LLC in the first place, the limited liability aspect of having a business structure separate to you, may not afford you the kind of protection you envision because you fail to follow business formality. So, what terms are material? Here's an answer you're not going to like. LLCs are governed by state law, and state laws differ from state to state greatly, so there is no one-size-fits-all answer. What's true in one state may be materially different from what the law is in another state. To make matters more complicated, terms of art in business can be defined and interpreted differently, or even be judged by a different legal standard entirely because every state not only has its own business law, but has different case law decided by its state courts. Case law are binding legal interpretations of law decided by a court as to how a legal issue should be interpreted. It is binding because subsequent courts are constrained by that interpretation. Every state has a separate and distinct state court system, and every state court system has a different set of case law about virtually every legal issue imaginable. Case law decided in one state court has no precedential value in the court of another state. Federal courts are, of course, different, but LLC business disputes are typically a state court matter. I say all this to let you know that any one-size-fits-all template or anyone claiming to have a one-size-fits-all solution should not be believed. You need to understand the business and litigation consequences of every line of your operating agreement based on your jurisdiction. Further, every business and every entrepreneur's pragmatic needs and circumstances are different. Where I've seen small business owners benefit the most is when they carefully research and draft their operating agreement based on the terms of how they want to structure their business in their best interest, and then and only then take their draft to a competent lawyer in their jurisdiction for consultation and revision. That way, the conversation had with legal counsel would actually be fruitful because their needs and wants had already been thoroughly thought out and documented, and therefore a lot of legal expenses are saved because the client is already educated on the legal issues that are important to them, and the lawyer only needs to revise and perhaps address the more nuanced details that are missed by the layperson. Because most of this stuff isn't complicated. It's not rocket science. Don't let lawyers who talk fast and use jargony words fool you into justifying costs into the dozens of hours. For most small businesses, yes, you probably need a lawyer. No, it shouldn't cost you $100,000 to structure your business. If money is an issue, the last thing anyone wants to do is to go into a lawyer's office and be charged every 6 minutes for the lawyer to explain legal concepts that you could have figured out on your own for free. You want to spend that expensive time going over the important issues that you can't figure out on your own or need clarification on. All right, this video is getting long. In the next video that I will drop in the next few days, we're going to put these concepts to use and dive into the details of operating agreements. And I want to share some winning setups that I like to use that I haven't really seen discussed on the internet. But as I always say, remember to always do your own research, do your own due diligence, and never wholly rely on some guy on YouTube, regardless of credentials or net worth. Even if you retain the services of an extraordinary lawyer whose skill and knowledge you've come to trust implicitly, the only way you become better at problem solving is if you understand the lenses through which the professional views the problem. The moment you stop learning, you begin to become irrelevant. Part 2 is coming shortly, and I'm going to be posting free content regularly. My core belief is that financial and legal information should be accessible to everyone and not behind some gate-kept institution. That anyone who desires financial success and who is willing to work hard and smart to obtain it will succeed. Cream will always rise to the top, regardless of where it starts. And open information is a prerequisite towards the ideals of a true meritocracy. I'm starting a community soon where I'm going to be sharing information that's not readily accessible anywhere else. It's going to be completely free for my subscribers, and hopefully I'll make that announcement of the details in the coming weeks. If this information has been helpful or entertaining to you and you'd like to see more, please do me a favor and hit that like and subscribe. I'll see you next time.